A federal judge has issued a binding subpoena requiring Ivanka Trump's testimony within precisely 10 days, marking what legal experts characterize as the most significant subpoena directed at a former First Family member in modern American history. The court-mandated order contains no latitude for negotiation and carries consequences that could fundamentally reshape established doctrines regarding executive privilege and familial immunity from legal proceedings. On January 22, 2026, Judge Patricia Whitman of the Southern District of New York approved a prosecutorial subpoena giving Ivanka Trump until February 1st to appear for sworn testimony regarding financial transactions occurring between 2017 and 2021. Sources close to the proceedings indicate the subpoena spans 37 pages and includes demands for testimony on specific real estate transactions, foreign business arrangements, and the alleged use of White House influence for commercial advantage. Multiple legal analysts who reviewed the filing informed reporters that the specificity of the questions and the narrow 10-day compliance window suggest prosecutors already possess substantial evidence and are using Ivanka's testimony to confirm what they have already uncovered through alternative investigative means. The subpoena was delivered directly to Ivanka Trump's legal team at 9:47 a.m. Eastern Time on Wednesday morning. According to courthouse sources speaking on condition of anonymity, the delivery was coordinated with U.S. Marshals to ensure proper service, a procedural step typically reserved for cases where prosecutors anticipate resistance or attempts to avoid legal process. One legal observer stationed outside the federal courthouse described witnessing a marshal's vehicle arrive with unusual security protocols. Within hours, news outlets confirmed that Ivanka's attorneys had formally acknowledged receipt, thereby initiating the official 10-day compliance clock. Ivanka Trump is no stranger to legal scrutiny or high-stakes negotiations. She served as a senior advisor to the president, participated in international meetings with heads of state, and maintained her own business empire throughout her Washington tenure. However, this situation differs fundamentally from anything she has previously confronted. This involves a federal judge appointed for life, exercising constitutional authority that cannot be ignored, delayed, or negotiated away like a business contract. Former federal prosecutor Sarah Mitchell, who spent 12 years handling white-collar crime cases in New York, told legal networks that a 10-day testimony requirement represents an extraordinarily aggressive timeline. Typically, she explained, subpoenas allow 30 to 60 days for compliance, especially when dealing with high-profile individuals who require time to prepare with counsel. The fact that Judge Whitman established such a compressed deadline signals one undeniable reality. The court views this testimony as urgent and considers any delay potentially harmful to the ongoing investigation. This subpoena did not materialize unexpectedly. It represents the culmination of an 18-month investigation that began in July 2024 when whistleblowers from 3 separate financial institutions filed suspicious activity reports with the Treasury Department's Financial Crimes Enforcement Network. Those reports, totaling more than 200 pages according to sources familiar with their contents, flagged irregular international wire transfers, unusual patterns of loan repayments, and potential violations of laws prohibiting the use of public office for private financial gain. By November 2024, a federal grand jury had been impaneled to review evidence, and subpoenas were issued to banks, real estate firms, and foreign business entities with connections to Trump Organization ventures. What investigators reportedly discovered was a complex web of transactions raising serious questions about whether official government actions and decisions were influenced by or coordinated with private business interests. Multiple sources briefed on the investigation's progress indicate that by December 2025, prosecutors had assembled a timeline demonstrating that specific White House meetings with foreign officials were followed within days by favorable business deals for Trump-affiliated companies. One particularly significant example allegedly involves a meeting in March 2018 where Ivanka Trump participated in high-level trade negotiations with representatives from a Middle Eastern country. Within 2 weeks of that meeting, according to banking records subpoenaed by investigators, a Trump Organization subsidiary received a $47 million loan from a bank controlled by that same country's sovereign wealth fund. The loan terms were characterized by financial experts who reviewed the documents as unusually favorable, with below-market interest rates and an extended repayment schedule that raised immediate concerns. When prosecutors presented this evidence to Judge Whitman in a sealed proceeding on January 15th, they argued that Ivanka Trump's testimony was essential because she was present at the government meetings, held an official White House position, and simultaneously maintained financial interests in the private companies that benefited. According to a legal motion partially unsealed after the judge's ruling, prosecutors stated they possessed communications suggesting Ivanka was directly involved in coordinating both the official government discussions and the subsequent private business arrangements. One text message allegedly sent from Ivanka's personal phone just hours after the March 2018 trade meeting reportedly reads, "The meeting went perfectly. They're very receptive. Let's move forward with the financing package we discussed. Timing is critical now." That message was sent to an executive at the Trump Organization, and prosecutors argue it demonstrates a direct link between her official duties and private business advantage. Judge Whitman's written order, filed publicly on January 22nd, includes language that legal scholars are characterizing as remarkably pointed. The judge wrote that the court finds compelling evidence suggesting that the line between official government duties and private commercial interests was not merely blurred, but potentially erased entirely during the relevant time period. She continued, stating that the public interest in understanding whether federal office was used for personal enrichment far outweighs any claimed privacy interest. This represents a federal judge essentially declaring in official court documents that sufficient evidence exists to justify compelled testimony under oath with criminal penalties for any false statements. Former Assistant U.S. Attorney David Chen told news networks that when a judge employs such language in a subpoena order, it means they have reviewed the underlying evidence and found it credible enough to compel testimony under oath with criminal penalties for any false statements. Within 3 hours of the subpoena being issued, Ivanka Trump's legal team filed an emergency motion seeking to quash the subpoena or minimally extend the compliance deadline to 90 days. The motion argued that the compressed timeline violated her rights to adequate legal preparation and that compliance would require producing documents and communications that might be protected by various privileges. Additionally, the filing claimed that forcing testimony on such short notice constituted harassment and prosecutorial overreach. Judge Whitman rejected this emergency motion within 24 hours, issuing a terse 3-page order stating that the defense had provided no legal basis for extending the deadline. The judge noted that Ivanka Trump has had access to legal counsel throughout the investigation's duration, that she was aware of the investigation's subject matter, and that the 10-day period provided adequate time to prepare for testimony about events in which she personally participated. The order concluded by stating that any further attempts to delay compliance would be viewed as obstruction and could result in contempt sanctions. The legal implications of this ruling extend far beyond one individual's testimony requirement. For decades, family members of presidents and senior officials have operated in a gray area regarding potential conflicts of interest. While laws exist prohibiting the use of public office for private gain, enforcement has been inconsistent, and prosecutions have been rare, particularly when they involve presidential families. The assumption has generally been that the political process, elections, public scrutiny, congressional oversight would provide sufficient accountability without requiring criminal prosecution. What makes the Ivanka Trump subpoena potentially paradigm-shifting is that it directly challenges this assumption. Prosecutors are essentially arguing that serving in the White House while maintaining business interests created opportunities for corruption that warrant criminal investigation, not merely political criticism. If this investigation results in charges and convictions, it would establish legal precedent that presidential family members serving in official capacities are subject to the same anti-corruption laws as any other government official, regardless of their relationship to the president. Constitutional law professors interviewed by major news networks emphasized that this case tests fundamental principles about the separation of powers and checks on executive authority. Professor Angela Martinez of Georgetown Law explained that the Constitution deliberately created a system where no individual, including the president and their family members, could wield power without accountability. However, she noted, the practical enforcement of this principle has always been complicated by political considerations, concerns about interfering with executive functions, and the difficulty of proving corrupt intent in cases involving policy decisions that might also benefit personal interests. The Fifth Amendment question adds another layer of complexity. Under the Fifth Amendment to the U.S. Constitution, no person can be compelled to provide testimony that might incriminate them in a criminal proceeding. This protection is fundamental to American jurisprudence and applies to everyone, regardless of their position or wealth. If Ivanka Trump appears for her deposition on February 1st, she has the constitutional right to invoke the Fifth Amendment in response to any question that might expose her to criminal liability. However, invoking the Fifth Amendment carries significant consequences, both legal and political. In criminal proceedings, prosecutors cannot use a defendant's invocation of Fifth Amendment rights as evidence of guilt. However, in civil proceedings, courts can draw adverse inferences from Fifth Amendment invocations, meaning they can assume the truthful answer to the question would have been unfavorable to the person refusing to answer. More significantly, from a public perception standpoint, repeatedly invoking the Fifth Amendment creates the impression that the witness has something to hide, even though the constitutional protection exists precisely to prevent self-incrimination without implying guilt. Legal experts analyzing Ivanka Trump's options suggest she faces a strategic dilemma with no clearly favorable resolution. If she testifies fully and truthfully, she might provide prosecutors with evidence that could be used to charge her, her father, or other family members with crimes. If she invokes the Fifth Amendment extensively, she protects herself from potential self-incrimination but creates political damage and might still face contempt charges if prosecutors argue she's invoking the privilege inappropriately. If she attempts to testify selectively, answering some questions while refusing others, she risks inconsistent statements that could be used to challenge her credibility or demonstrate consciousness of guilt. The investigation's scope extends beyond the specific transactions mentioned in the subpoena. Federal investigators have reportedly been examining whether the Trump family's business dealings during the White House years violated multiple statutes, including the Foreign Corrupt Practices Act, which prohibits offering or receiving anything of value to influence foreign officials. The Emoluments Clause of the Constitution, which prohibits federal office holders from receiving payments from foreign governments without congressional consent, and various fraud and conspiracy statutes that might apply if financial documents were falsified or if there were coordinated efforts to conceal the true nature of business arrangements. Sources familiar with the investigation told reporters that prosecutors have been particularly focused on tracing the flow of money from foreign sources to Trump-affiliated businesses and attempting to establish whether there were quid pro quo arrangements, explicit or implicit understandings that favorable government actions would be exchanged for business benefits. Proving quid pro quo in corruption cases is notoriously difficult because it requires demonstrating not just that money changed hands and government actions occurred, but that there was a causal connection between the two based on corrupt intent rather than legitimate policy considerations. However, the text message allegedly sent by Ivanka Trump after the March 2018 meeting, if authentic and admitted as evidence, could be particularly damaging because it appears to show a direct temporal and causal link between an official government meeting and subsequent private business actions. Prosecutors would argue that the message demonstrates consciousness that the government meeting created a business opportunity and that timing was critical to capitalize on that opportunity before circumstances changed. Former ethics officials from multiple administrations have stated publicly that the Trump family's approach to White House service created what they characterize as structural corruption. Even without provable quid pro quo arrangements, the mere fact that foreign governments and business interests understood they could potentially gain favor by conducting business with Trump companies created corrupting incentives that undermined public trust in government decision-making. Former White House ethics lawyer Craig Daniels, who served in both Republican and Democratic administrations, told news networks that the Ivanka subpoena represents a fundamental test of whether our legal system can hold powerful political families accountable. He emphasized that if Ivanka can successfully resist this subpoena or avoid meaningful consequences for refusing to comply, it sends a message that wealthy and politically connected individuals operate under different rules than ordinary Americans. Conversely, if the legal system can compel her testimony and follow through with prosecutions that the evidence supports, it demonstrates that no one is truly above the law, regardless of family name or political connections. This is not abstract legal theory. This concerns whether our constitutional system of checks and balances still functions when confronted with individuals possessing resources to fight every subpoena, appeal every ruling, and delay proceedings for years. The investigation is not occurring in isolation. It unfolds against the backdrop of multiple ongoing legal challenges facing the Trump family across different jurisdictions. There is the New York civil fraud case that resulted in hundreds of millions in penalties. There are criminal indictments related to attempts to overturn the 2020 election results. There are defamation lawsuits and investigations into the handling of classified documents. Each case is separate and distinct, but collectively they create a pattern where legal accountability that was long delayed or avoided is now arriving simultaneously. The Ivanka subpoena is particularly significant because it focuses on a time period when she held official government power, making potential legal violations more serious and constitutional questions more complex than cases involving purely private business conduct. Legal analysts are also monitoring how this case might affect Donald Trump's current presidential campaign. While Ivanka herself is no longer involved in her father's political activities in any public capacity, testimony about White House operations, business dealings, and the intermingling of government power with private profit could provide damaging information for political opponents. Every revelation emerging from her testimony, every document entered into evidence, every email or text message demonstrating coordination between official duties and business interests will immediately become campaign material. Because this is occurring under court order, with testimony given under oath and penalties for perjury, the information carries far more weight than typical political attacks or opposition research. Campaign strategists from both parties told reporters that Ivanka's testimony could become one of the defining moments of the 2026 election cycle, potentially reshaping public perceptions about the Trump family's time in power and their fitness to return to the White House. As we approach the February 1st deadline, Ivanka Trump and her legal team must decide whether to comply with the subpoena, invoke Fifth Amendment protections, or attempt some form of last-minute legal maneuver to delay or avoid testimony. Each option carries significant risks and potentially life-altering consequences. Judge Whitman has made clear through her rulings that she will not tolerate delays or procedural games. The investigation behind the subpoena appears extensive, well-documented, and focused on specific allegations rather than vague fishing expedition tactics. The legal precedent being established could affect how future administrations handle conflicts of interest, nepotism, and the boundaries between public service and private enrichment. Multiple former prosecutors told reporters that the urgency reflected in Judge Whitman's 10-day deadline suggests additional factors at work behind the scenes. Federal investigations typically proceed at a deliberate pace, requiring months or years to build cases and secure testimony. When a judge compresses that timeline and demands immediate compliance, it usually indicates prosecutors have a specific reason for requiring the testimony quickly. One possibility is that they are preparing charges against other individuals and require Ivanka's testimony to complete their case before a grand jury term expires. Another possibility is that they possess evidence suggesting document destruction or witness tampering and want to secure Ivanka's testimony before anyone can coordinate stories or alter evidence. A third possibility is that prosecutors are under pressure from higher authorities to conclude the investigation within a specific time frame and cannot afford further delays. A fourth and perhaps most concerning possibility is that prosecutors have intelligence suggesting Ivanka might attempt to leave the country to avoid testimony, and the compressed deadline is designed to prevent that scenario. Legal sources speaking on background indicated that in high-profile cases involving wealthy defendants with international connections, prosecutors often worry about flight risk, even when no formal charges have been filed. A federal judge has ordered Ivanka Trump to provide sworn testimony within 10 days about her role in potential conflicts of interest and abuse of office during her White House tenure. The subpoena is legally binding. The deadline is firm, and Judge Whitman has rejected all attempts to delay or avoid compliance. Legal experts characterize this as one of the most significant moments in the ongoing saga of accountability for the Trump administration's blurring of public office and private business interests. The testimony Ivanka provides or refuses to provide could determine whether criminal charges follow, whether other witnesses face similar subpoenas, and whether our legal system can effectively hold politically powerful families to the same standards as everyone else. This is not merely another news cycle that will fade away. This represents a legal reckoning years in the making. The evidence has been gathered. The grand jury has been impaneled. The judge has ruled. Now Ivanka Trump must decide whether to enter that hearing room on February 1st and answer questions under oath about what transpired when government power and private profit became impossible to separate. The stakes have never been higher. The deadline has never been more compressed. The constitutional principle of equal justice under law has never been more directly tested. The next 10 days will determine whether accountability still means anything in Washington or whether powerful families can successfully resist legal scrutiny indefinitely. What happens next will define the boundaries of executive power and family immunity for a generation.